may briefly discuss the chronology of events which led to this ruling.
So actually things happened between 2020 and 23, 12 bills were passed by the State Legislative Assembly of Tamil Nadu. They were pending with the Honorable Governor.
How exactly Supreme Court has interpreted the whole issue?
Governor sitting over bill is actually a matter of concern, and Supreme Court had tried to ensure that the legislature remains the most powerful when it comes to lawmaking, whether state assembly or parliament.
Veto powers which the governor can use while giving assent to the bills passed by state legislature.
Article 200 of the Constitution tells how the governor is supposed to act when the legislature, which might comprise a single house or two houses, passes a bill and the bill is reaching the governor.
Hello everyone, welcome to the Perspective series. Today we are diving deep into a recent landmark judgment passed by Supreme Court on 8th of April 2025 regarding the delays made by governor in giving assent to the bill passed by the state legislature, popularly known as the Pocket Veto case. This judgment is truly going to reshape our understanding of governor's power and his legislative autonomy. So today we are going to discuss thoroughly regarding this recent Supreme Court judgment by our expert panel members today. A very warm welcome to all of you. So before starting the discussion, it is very important to know what made Supreme Court to give this ruling now. So I would like Amil Sir to briefly discuss the chronology of events which led to this ruling.
Thank you. Actually, this is a very pertinent question because there is lack of literature available in public domain related to the chronology. So actually things happened between 2020 and 23, 12 bills were passed by the State Legislative Assembly of Tamil Nadu, and they were pending with the Honorable Governor. So on 31st of October 2023, the state moved Supreme Court that the bills have been kept pending. Okay, with respect to that. On 10th of November 2023, the Supreme Court issues a notice to the governor to reply. So on 13th of November, 3 days after the Supreme Court took action, the Honorable Governor sent 2 of the bills to the President and 10 bills were withheld. Now here there is a confusion because the Honorable Governor in the affidavit filed in Supreme Court is of the opinion that the assents were withheld. And the State Legislative Assembly was communicated that the assent has been withheld. But the Honorable Chief Minister and the Council of Ministers took an interpretation that no, the Governor has asked to reconsider the bill. Okay, so because the Governor's side is withholding the assent to the bill and communicating to the Legislative Assembly. So anyways, the Honorable Governor on the advice of Chief Minister called a special session on 18th November where all the 10 bills were again passed by the Legislative Assembly and asked under Article 200 of the Constitution for reconsideration, which we will come later because the entire issue stems from Article 200 and which needs a very nuanced and fine understanding, not for just literal word nuanced and fine, actual understanding of Article 200, which we'll see later. So, and again the bills were again passed by the Legislative Assembly and sent to the Governor. This time the Honorable Governor sent the bills to the President for for assent under Article 200. Now the Honorable President assented some of the bills and some of the bills, so most of the bills were rejected and one was approved and some were asked to reconsider. So this judgment was delivered by Supreme Court this month on 8th of April that using powers under Article 142 of the Constitution, the Supreme Court for the first time deemed that those 10 bills which were sent by the Governor to the President would deem to have been approved by the Governor. Reason? Because the Supreme Court took a reason that second time when they were sent by the Legislative Assembly to the Governor, second time the Governor cannot send it to the President. The same could have been done for the first time. So, and next day the Honorable Chief Minister and the State of Tamil Nadu, they notified these 10 bills in the Gazette that these 10 bills have been deemed to be approved by the Supreme Court, which is actually first time in history. So this was the chronology. 2-3 things are there. One is related to, of course, federalism, which we discussed throughout the year. Second is the literal interpretation of Article 200 of the Constitution and how distinct it is from Article 111, which is the power of President to approve a bill passed by the Parliament. Third important aspect related to it is related to which we commonly discuss, to what extent the judiciary has encroached into the domain of legislature or executive, if any. That remains a very, very debatable thing. So this is the brief synopsis gist.
Now that we know the detailed chronology of events, I would like Kanishk Sir to maybe throw a light how exactly Supreme Court has interpreted the whole issue in this judgment.
As Sir rightly said, that Supreme Court has invoked Article 142, which is the plenary power of Supreme Court to do complete justice. Governor sitting over bill is actually a matter of concern, and Supreme Court had tried to ensure that legislature remains the most powerful when it comes to lawmaking, whether state assembly or parliament. Now, reserving the bill by the governor has delayed the bills. He sent some to the president's consideration. Now, which bills can be sent to the president for consideration by the governor? Constitution is silent on it. There are two indirect references in Constitution. One is your Article 213 subclause B and 254 clause 2. But it nowhere says that a bill on 254 says that a bill on concurrent list can be reserved by the governor if it is repugnant to an existing central law, and 213 is the ordinance making power. In 2023, there was a judgment, Punjab government was involved there, where Supreme Court gave this judgment. What this time court has done is to ensure that the unelected governor will not be able to supersede over an elected legislature. But the manner in which it has been done points towards some glaring inadequacies. Let me point towards few. 142 is the plenary power, and Supreme Court itself in Prem Chand Garg case has put some restrictions on the use of this plenary power. It cannot be used too frequently. Secondly, this judgment has been delivered by a division bench. 145, Article 145 mandates that at least a constitutional bench of 5 judges should interpret the Constitution. They are also saying that President ought to refer the matter to the Supreme Court under Article 143. Presidential reference should be used if President is not sure whether the bill reserved by Governor is violating the Constitution or not. But Article 143 is purely an executive power. Supreme Court cannot say that President ought to use this. So there are certain issues which I see, and if not sorted on time or at the right time, then it may lead to a confrontation between executive and judiciary, is how I see it.
Now that we know what exactly Supreme Court has shown, I would like ma'am to maybe answer what does the rule book, the Constitution says all about this, and what has been the timeline set up by Supreme Court regarding the veto powers which the governor can use while giving assent to the bills passed by state legislature.
Fine. Yes, Paritosh, it's a pertinent case that we are discussing here. So, according to the Constitution, Article 200 of the Constitution tells how the governor is supposed to act when the legislature, which might comprise a single house or two houses, passes a bill and the bill is reaching the governor. In that case, the governor has 3 options. He gives the assent, he withholds the assent, or he reserves the bill for presidential consideration. Here the article also mentions 2 provisos. Yes, 2 exceptional situations. So in the first exceptional situation, you find that the article says that in case the governor has some concerns with respect to the bill, in that case the governor can send back the bill to the legislature, and with asking the legislature to reconsider the entire bill or certain specified provision within the bill. Yes, and the legislature is expected to reconsider the bill or the specified provision, look into if they can bring the necessary amendment as suggested by the governor or whatever to satisfy the concerns expressed by the governor, and whatever they decide, once the bill is repassed by the legislature and it reaches back the governor has no other option but to give assent to the bill. This is what proviso 1 says. Paritosh, there is also the second proviso which says that if the governor feels going against the wishes of his COM, he feels that the given bill will derogate from the powers of the High Court as has been mandated by the Constitution, would affect its functioning as has been mandated by the Constitution. In that case also, he can reserve the bill for presidential consideration. In fact, it becomes obligatory for him to reserve the bill for presidential consideration there. So this is what Article 200 as such, the Constitution says. Yes, and now we have seen over the years, there have been incidences where the governors have used their powers to indefinitely delay the bills. Yes, So this time the Supreme Court has taken the view that this would not be permissible. It tantamounts to a pocket veto or an absolute veto, which is unconstitutional, and it has in fact set timelines for the governor to act upon. So it says, the judgment says that in case the governor is to give assent to the bill, to withhold assent, or to reserve the bill for presidential consideration, in the very first instance, he is going to do it within the period of 1 month when the bill is presented to him. And in case he is going to act against the wishes of his COM, against the advice of the COM, and reserve the bill for presidential consideration, then he has been given 3 months to do the same. And once the bill has reached the governor after consideration by the COM, when he had sent the bill for reconsideration and it has reached the governor back, in that situation, within a month's time, he is to necessarily give assent. So this is the timeline set by the Supreme Court judgment, and it is a judgment basically to uphold the rule of law, and seems like upholding constitutional morality from my perspective.
So now that we have a very nuanced understanding of the whole issue, I would like Amil Sir to maybe throw a light that how exactly things are going to change after this.
So it is a very complex issue. Multiple things are there because, the issue is because the constitution is the supreme law of the land. But Supreme Court would say what is the constitution, because Supreme Court is the final interpreter of the constitution. Second things, one must understand that the constitution speaks in a different manner. For example, there is no term like pocket veto, absolute veto, what you call suspensive veto or qualified veto in the constitution. Article 111 or 200 for president and governor respectively, they use the term withholding assent, which is called in the textbook usually as absolute veto. Since no time is given in the Article 111 or 200, so it is deemed as pocket veto. Since the president can ask the house to reconsider the bill, then it is called as suspensive veto. But the term absolute, qualified, suspensive or pocket veto is not used in the constitution. So the constitution uses a different expression but expects the president and governor to act on the advice of council of ministers. For example, says so many, see, I am telling you, it will take a bit of time, then it will be open to a better clarity. Article 74 of the constitution only says that the president shall act on the aid and advice of council of ministers. He can ask to reconsider, second time it will be binding. Similarly, article 163, the governor shall act on the aid and advice of council of ministers, except if the constitution asks him to act in discretion, then only he can act in discretion, which is mentioned. But other than that, for example, Article 53, the executive power of the union shall be vested in the president. Article 77, president shall, all executive actions of government of India shall be taken in the name of president. Article 77, clause 3, the president shall make rules for the convenient transaction of the business of the union. Article 85, the president shall summon and prorogue the sessions of parliament. Article 315, and the appointment of the UPSC and chairman. Article 324, chief election commissioner. So the constitution is all pervasive that president will do these things, but it is quite commonsensical that the president and the governor will do these things on the advice of Council of Ministers. One more thing, Dr. Ambedkar said in the Constituent Assembly that the position of the president in India is similar to that of king under the English Constitution, but I'm not going to the president. Now let's come to the governor. The entire issue is interpretation of Article 200. Let's understand that. Article 200, first clause says that when a bill is presented to the president, a governor, as soon as possible, shall communicate what? Withhold assent, one. Second, give assent. So, or reserve the bill for the consideration of the president. Okay. So, these are the three options. But in the proviso, it says there are two provisos, matlab qualifications, conditions, exceptions. It says that the governor may ask the house to reconsider the bill, which, as very rightly ma'am said, if the house reconsiders the bill, then second time it becomes binding on the governor. So first line it says withhold assent, give assent, refer the bill to the president. But second proviso says that the governor can ask the house to reconsider. But the problem is that in the first clause it is written shall. The governor shall, shall as soon as possible, which in the Constituent Assembly, Dr. Ambedkar also said initially it was 6 weeks, but later on they agreed, okay, let's have as soon as possible, shall. But in proviso to clause 1, it says may ask the house to reconsider. So let me just break it down. The entire issue stems from one point. The union government is of the opinion that governor has 4 options. One, he can withhold assent. Second, he can refer the bill to the president. Third, he can give assent to the bill. Fourth, he can communicate the house to reconsider the bill. So this is mentioned in the affidavit filed by union. They have 4 options. They can withhold assent, ask the house to reconsider the bill. Second option, they can give assent or reserve it for president. But the Supreme Court is of the opinion that in the first clause it is mentioned that shall should be read with may. So Supreme Court has said no, there are not 3 powers, there are not 4 powers, there are only 3 powers. Governor can either give assent, governor can reserve the bill for the consideration of president, and third thing, governor can withhold assent, but in that case governor shall send the bill back for reconsideration. So actually Supreme Court is taking away the power of pocket veto. Central government is saying no, governor can withhold the assent or he can send the bill for reconsideration. Supreme Court is saying no, he can withhold the assent, then in that case he will ask the house to reconsider the bill. Then reserving the bill for the consideration of precedent. In this, Supreme Court in its judgment highlights 3 things. One, that Article 31C of the Constitution, that is in any law that seeks to implement 39B and C, if it is enacted by the state legislature, it will be assented by the president. Or a bill that endangers the position of High Court, or an interpretation if the bill that is against the constitution, and then you have Article 254, inconsistency between the parliamentary and state law. So in all certain ordinances that are made, then you need the permission. Other than instances, if the bill is not directly violating the provisions of constitution, then the governor shall not what you call refer the bill to the president. So finally the Supreme Court narrowed down the power of governor, that you can give assent, you can withhold assent, reserve for president. But in withholding assent, which is in Article 200 clause 1, always have to be read with proviso 1, that withhold assent and then you have to send it to the state legislature. Now I would like to go to 17th July when 1949, this Article 175 of the draft constitution and Article 200 of the present constitution was discussed in the Constituent Assembly. 3 changes were done. It was written in the draft constitution that the governor at his discretion. So Dr. Ambedkar introduced this amendment that no, we will remove the term at his discretion. So first this was removed. So 3 amendments were introduced to the draft Article 200. First was in the original draft article which was introduced in the Constituent Assembly, it was written that governor will have discretion. This discretion term was deleted by the Constituent Assembly. Matlab Constituent Assembly also did not want to give discretion to the governor. Second amendment which was brought, that they will not send the money bill for reconsideration, which was added in proviso 1 of the article 200. Third thing which the Constituent Assembly did, any bill that endangers the position of High Court shall compulsorily be reserved for the consideration of precedent, because High Court, if the state reduces the pecuniary jurisdiction of High Court, so the territorial, the principal seat and all these things come under the center, so it will lead to a conflict. So 3 amendments were done, but we are not concerned with 2 amendments, we are concerned with 1 amendment. So first, the Constituent Assembly took away the discretion of the governor, so the intent of the lawmaker, the founding mothers in the Constituent Assembly wanted to remove the discretion which has been ruled by Supreme Court. Now let's the impact is on what will be the impact, as you very beautifully asked, what will be the impact on federalism. There are 2 possibilities. First possibility is that Article 137 of the Constitution allows the Supreme Court to review any of its judgment. Second possibility is under Article 143 of the Constitution, any question of law or fact that is of public importance, the President can seek an opinion. So diverse opinions are emanating from in the quality, the kind of literature that we are accessing, newspaper and all. The central government may file a review petition under Article 137, which is very likely, or the Honorable President of Republic will seek an opinion from the Supreme Court under Article 143 of the Constitution. The Supreme Court in last paragraph, 414-page judgment, I was going through, not all but comprehensively. In the last part, Supreme Court said, is reminded on 25th November 1949, what Dr. Ambedkar said, however good a constitution you make, if the people working on it are bad, they will make bad. However bad a constitution we make, if the people working on it are good, they will make good out of it. So it is not about the interplay of articles. It is how your constitutional morality is towards the commitment towards the constitution. One last thing I would say, there are zillions of provisions in the constitution There are zillions of provision where the Supreme Court has interpreted differently. For example, 10th schedule, it is written the decision of speaker shall be final, but Kihoto Holahan versus Zakilu, Supreme Court said no, it is not final. For example, in Article 109, read with 110, speaker's decision on money bill shall be final, but Roger Matthew versus South Indian Bank Limited, Finance Act of 2017, Section 184, the Administrative Tribunals Act of 1985 was amended. Supreme Court Constitution bench will see whether that can be classified as a money bill or not. For example, the state of Punjab moved against the governor for not calling an assembly session. So there are Rameshwar Prasad versus Union of India, the honorable governor had to resign. So, and you have other case in state of Punjab also, Supreme Court has clarified that governor must act on the aid and advice of Council of Ministers. See, the point is there must be commitment to the constitution. Clearly it was said in the Constituent Assembly that the office of governor is being, one more thing which has been highlighted, that Article 200 is not the power of governor, but the function of governor. There is a difference between power and function. Power is the ability to control someone else's decision. Function is your duty. So Article 200 casts a duty upon the, upon the governor to approve the bills. It is not his authority because the bill reflects the will of the people of state of Tamil Nadu. Okay, one thing that is there that sir very rightly said, कि judicial, thoda sa judiciary, because it was a question that required, he very rightly said, it required an interpretation of the constitution. So better it should have been done by the constitution bench as mandated by Article 145, 5 judges. Supreme Court, we don't have single judge bench, we have 2 judge benches and more. But in Article 131, if there is a dispute between center and state, there is no mandate that there should be 5 judges. There have been judgments where not necessarily, but this he, very explicitly pointed out that this is an interpretation of 200. So I think that it should have been done by the constitution bench. So lastly, let's wait, okay, because this will have far reaching implications. State of Kerala has also moved. I told you this can take 5 hours, so I'll stop over here. So I think that let's wait. Article 137 and 143 or any other route which the parliament also has, the legislative route, but that is too naive to say at this status. So I think this is my observation over the same.
Truly, the viewers would have got a very comprehensive understanding about the whole issue. Now, I would like to ask Kanishk Sir to maybe throw a light that does this happen at a global level as well? Like the like democracies over the globe also face this issue of maybe executive interference in the legislative matters. If yes, how are they dealing with such instances?
Not to the extent that we are witnessing right now in India. In US, you have a 10-day maximum time. If the president does not assent, it will automatically turn into the law. In UK, you see, there is a famous saying in Britain that the king is bound to sign his death warrant. So the crown does not act to the contrary. Countries like France and all, they have a very evolved and developed parliamentary conventions. So it has not happened. See, Indian Federation, like Avery Jennings said, it's a federa sua genere of its own type. And it leans in favor of the union. Of course, federalism is a part of basic structure. But then some things are not directly mentioned. Basic structure itself is a judicial innovation, so is collegium. So the way I see it, that the judgment by Supreme Court is on par with the Constitution. They are trying to inculcate the constitutional spirit and ensure that the unelected governor does not bulldoze his way down to the legislature, which is representing the will of the people in the state. But again, the glaring inadequacies that I pointed towards, Article 143, the judgment also says that if the president is not sure that whether the bill reserved by governor is unconstitutional or not, then she ought to seek advice from the president under Article 143. But Article 143 is completely a power of executive. Supreme Court saying that ought to do it is unprecedented. This is judicial overreach in my view. So the right thing would have been that Supreme Court would have directed the center and the state to sit together, work it out, maybe more of zonal council meetings, interstate council meeting. I'm reminded of a case, KM Singh versus Honorable Speaker Manipur in 2020, where Supreme Court did not give a judgment. It gave an observation that should Speaker continue to be a part of the ruling party. Let all the political parties contemplate upon it, and that's the right way to do it. Keshav Singh case 1962, the confrontation between the two organs reached to such height that the President of India, CJI, all need to sit together. It was regarding a violation of privilege of the House. So let us not move towards that era. Let us put our acts together, more contemplation, more deliberation instead of confrontation. And see, Supreme Court or judiciary does not have any agency of its own. They are dependent on the same executive. If the executive, God forbid, refuses to abide by the judgment and observation, it would be a very sad day for constitutional democracy in India.
Thank you so much, sir. Now let's conclude the discussion. I would like ma'am to maybe throw some light that how do you see this whole scenario of judiciary taking a stance towards this whole issue?
Paritosh, of course, as the alternative view has been rightly pointed out by Kanishk Sir, the question ultimately arises, we can deliberate, as Sir said, on the actions taken by the Supreme Court, but ultimately the question does arise that when the governor fails the legislature or the executive, where does the executive find solace in? So we can carry on our deliberation further, but once again, as rightly pointed out by Amil Sir and in the judgment, that as Dr. B.R. Ambedkar, Baba Saheb Ambedkar had rightly pointed out that the constitution is dependent on the people who are going to make the constitution work or not make it work. So in that sense, it is essential that we cannot let the mandate of the people, let's not forget we are in a democracy and the will of the people is represented by the representatives. It's a representatives in the parliament. Yes, and it's a parliamentary democracy where executive is drawn from the legislature. So once the executive makes a law and the parliament and the state legislature here passes it, then it would not be right for an unelected representative and appointee who is to serve as the constitutional head of the state to not fulfill his or her duty. So that being said, of course, it's a very important judgment. It once again upholds constitutional morality. It tries to uphold rule of law, constitutionalism, clearly telling the governor that you cannot not take action. You cannot ignore the views of the people as has been expressed by the state executive or the state legislature for that matter. Yes, so that is the scenario. Now let's see, the judgment has been given. How the future shapes up, what is the future course of action as it follows, and the judgment has been given, but the execution, I guess, would remain the key. Yes, we will have to see if, as per the judgment, the governor abides by the timeline and upholds the mandate of the people.
Would you like to, sir, add on?
I'm in agreement with what Sir and Ma'am said. My only difference is on the method through which it is executed. I am reminded of former Attorney General Mr. K.K. Venugopal while arguing a case in Supreme Court. He quoted Jawaharlal Nehru, the first Prime Minister from Constituent Assembly debate, and said that is Supreme Court trying to become the third chamber. So you see, legislature is the one who will pass the law. Judiciary deciding that if governor or president has not ascended the law, then within the stipulated time frame, if it elapses, it turns into law, is where Mr. Venugopal was pointing towards, that judiciary trying to become the third chamber. So let that not be the case.
Okay. Thank you so much for joining us today. It was indeed a very thorough discussion regarding the particular judgment passed by Supreme Court. Thank you so much. To our viewers, if you like the video, please share and comment what exactly are the views regarding the Supreme Court ruling and how exactly it is going to change the center-state relations moving forward from now. If you like the video, please subscribe the Perspective series. Until next time, stay aware, stay updated.